Welcome to Horns of a Dilemma, the podcast of the Texas National Security Review, which is a partnership between War on the Rocks and the University of Texas at Austin. My name is Carrie Anderson, production editor for TNSR. On this episode, Marshall Kosloff talks with Luke Schumacher about his recent article in TNSR called Franklin D. Roosevelt, World War II, and the Reality of Constitutional Statesmanship.
Luke Schumacher, welcome to Horns of a Dilemma.
Thanks, Marshall. Huge fan of the podcast, so delighted to be with you.
Really excited to speak with you. So why don't we just kick things off by going into your background a little bit, both as a person who served in the Army, but also as a person who has pursued multiple careers in academia, everything from the law degree to obviously the PhD, because I think your interests in that category are really encapsulated by where this article turns out.
Yeah, I was in the Army for about 7 years after graduating West Point. Had the great fortune to spend most of my time abroad. South Korea, Afghanistan, elsewhere in Asia. And after leaving active duty, started a PhD program in political science where I focus on international relations and also law school. And this article does really, kind of reside at the intersection of all of my major academic research interests. It's been really long in the making, this article, probably longer than I'd care to admit, but it kind of started when I was a cadet at West Point. I think it was the summer of 2012. I got to participate in a small class that went to England where we studied some of the historical and philosophical roots of the American Republic. And because we're future Army officers in the UK, we also studied a little bit of the special relationship between the US and the UK. We discussed statesmanship and grand strategy in World War II on both sides of the Atlantic. And a lot of the stuff we were reading and talking about kind of dealt with these two concepts, constitutionalism and statesmanship, in isolation. But we were also assigned one reading, a short essay by one of UT Austin's own, Jeff Toulis, called The Possibility of Constitutional Statesmanship. And that article says sometimes two good things don't go together, constitutionalism and statesmanship, or at least there's some kind of tension between those two things.
Given the importance of terms here, can you just define constitutionalism and then statesmanship on their own? Like, what are you invoking when you're bringing up both of those ideas?
Constitutionalism, I just think about constitutionalism in its modern manifestation as a method of limiting government power, and statesmanship being the leader's prerogative to pursue the public good. And what Toulis's point was, kind of picking up on a thread first laid down by political philosophers like Herbert Storing and Walter Burns, is that constitutional statesmanship is something of a paradox. Walter Burns, once wrote that we Americans are all in favor of constitutionalism and we are all in favor of statesmanship. And something I try to do in the article is make the point that there are trade-offs between those two concepts that kind of preclude optimizing both simultaneously. And statesmanship's something we can trace back to the ancients in classical antiquity, who described it as this power tempered by prudence to pursue the public good. But once we attach the qualifier constitutional in front of it, I think that kind of circumscribes the scope of statesmanship in two ways, just as a linguistic matter. First, it implies that the public good that the statesman is pursuing has to be the kind of good as her constitution defines it. And secondly, the way in which she pursues that public good has to be consistent with her state's broader constitutional arrangement. And that's kind of where we have a problem. I think it's a larger problem for modern constitutional orders than it was for ancient ones. But essentially, the problem is this. What if pursuing the public good requires the violation of constitutional rules or structures? And John Locke had a solution for this. He called it executive prerogative. An executive prerogative was the power to act with discretion for the public good without the prescription of law and sometimes even against it. And that power could be necessary for any number of reasons. The legislature is not always in session, so the executive has to exercise discretion. The legislature is too large or too numerous to make quick decisions during an emergency, or because the law is just inherently incomplete. It can't foresee all possible contingencies, and even rules on the book, if they're inflexibly applied, could sacrifice the public interest. But critically for Locke, what made prerogative power compatible with a consent-based government, and in my mind, what makes statesmanship compatible with constitutionalism is the fact that after the executive exercises that power, he has to throw himself at the mercy of the people for their retroactive judgment. And a textbook case of this, just to kind of illustrate what constitutional statesmanship looks like ideally, I think is Abraham Lincoln at the outset of the Civil War, right? So in April 1861, when Fort Sumter is attacked, Lincoln takes a series of unilateral actions because, as Locke predicted, the legislature was out of session. So he takes several actions without legal license, and some things, frankly, just against the law. And I think it's statesmanlike because his aim was to do the public good. It was to preserve the Constitution by preserving the Union. But what made that statesmanship compatible with constitutionalism is really what he does afterwards. He reconvenes Congress on July 4th, 1861, and explains what he'd done. He says, I took some actions that I think were legal, such as imposing this naval blockade to repel a sudden attack. I did some things that might be constitutional, like suspending habeas corpus. And then, frankly, I did some things that were probably unconstitutional, but required by necessity, like using funds that weren't appropriated to buy weapons. He puts himself at the hands of Congress then and says, if I abused my power, impeach me. But if I didn't, indemnify me. Legalize retroactively my actions. And I think that's textbook constitutional statesmanship. Not something, I deal with in this article where I focus kind of narrowly on the case of Franklin Roosevelt as he prepared for and waged war, but I think a really good illustration of what I'm trying to explain.
Well, you kind of really set up my next question really well there, which is why then not write this article on the case study of Lincoln and the beginning of the Civil War in 1861? Why is the pre-war and wartime United States of FDR actually the proper place to write an article like you're writing?
I think because there's been quite a bit written on Lincoln. In fact, I don't know if it's true, but I've heard that there's more written on Abraham Lincoln than any historical figure other than Jesus Christ. And Roosevelt's he's up there as well. There's no doubt there's a lot of scholarly and popular interest in the legacy of Roosevelt. But I did feel like a lot of the work kind of interrogating constitutional statesmanship, whether statesmanship is compatible with constitutionalism, what it might mean to talk about a statesman that is constitutional, really kind of exists at the theoretical level. And this struck me as an empirical question. And perhaps because of how I told you about the formation of this idea, I'm in the UK thinking about World War II. It just seemed like a great candidate to figure out some of the possibilities and limits of constitutional statesmanship, looking at FDR in World War II. And I think, I do choose the case advisedly because, like Lincoln's actions at the outbreak of the Civil War, FDR's this period of history in the late 1930s and in the World War II really does throw into the starkest relief the tension between constitutionalism and statesmanship, because on the one hand you have the demands of war that just cry out for statesmanship to secure the public good in the form of a victory. And on the other hand, you have the dictates of constitutionalism, and it's on the Constitution's behalf that FDR claims we're waging this war. So it would have been difficult to find a more striking case that kind of shows the tension but necessity for both of these things at the same time.
I think what's kind of fascinating here is, as I'm thinking of these two examples, there's this weird historical coincidence almost where Lincoln barely outlives the war, but FDR doesn't outlive the war. But, Lincoln doesn't make it much past the end of the Civil War. And I think what that kind of brings to mind is, if we're thinking in Lockean terms, or if we're thinking about the sort of dangers or worst case scenarios of this tension points, are there any alternative examples or case studies where we really see what goes wrong long term when the tensions between constitutionalism and statesmanship aren't properly balanced? And the reason why I was establishing both of the deaths of those two statesmen is that it basically meant that long term there was no long term. You could really focus their actions concretely and discernibly in the period of the Civil War and World War II. But do you have any thoughts on that question?
Yeah, sure. And it's something I elaborate a bit in the conclusion of the article, where I try to illustrate some of the attempts by FDR successors to build on the legacy that he set. And one case I kind of drill into is Lyndon Johnson's presidential leadership of the Vietnam War. And in many ways, he's, I think, building on the FDR legacy. He considers Roosevelt a hero of sorts. And I see a lot of parallels between his Americanization of the war in Vietnam and FDR's leadership in World War II. Of course, the Vietnam War goes in a very different direction than World War II. And perhaps that's why we have different conceptions of these presidents' legacies. But Johnson kind of follows the Roosevelt playbook to the T, in the same way that Roosevelt was prosecuting an undeclared naval war in the North Atlantic for about 2 years before Pearl Harbor. Sending out famously the USS Greer, a destroyer ship, into the North Atlantic with British aircraft overhead, trying to bait German U-boats into attacking. Johnson also sends destroyers into North Vietnam, trying to bait an attack that would justify an American reprisal. And Johnson gets that reprisal in the same way that FDR tried to spin the Greer incident, but Johnson's more successful in some ways by actually getting an authorization for the use of military force. And that war just goes in a different direction, and that might be why we call one a constitutional statesman, as I kind of do in the article, and we call the other kind of an example of executive abuse. And this is why Senator Fulbright in 1971 is making a speech on the floor of the Senate and says the precedents that FDR established in a good cause made it far easier for LBJ to exercise deviousness in a bad cause.
I want to zoom out real quick. I would like to hear your thoughts on a statement you make in the piece, which is that you reflect that, quote, statesmanship receives little scholarly or popular interest today. I'm curious what you think is going on there.
Yeah, I think I might take them in turn, because I think the answers for why it receives little scholarly attention and popular attention might be a bit different. At the risk of overgeneralizing, scholarly work on executive power, at least in America, can be divided into two major schools. The first we might call the formal school, and that's really popular in legal academia, where scholars evaluate presidential performance normatively by considering how well the president bore faith to the Constitution, his constitutional fidelity. And the second we might call the realistic school, and that's really common among the political scientists. And those scholars try to evaluate the president according to how successful he was in getting his way. And a statesman doesn't really neatly fall into either of those categories, right? He's got to sometimes skirt, bend, and break the law, and break those formal rules. So the formal school doesn't really praise him, but the statesman's also exercising prudence as he bends those rules. He's bending them in service of the public good, not because he wants to aggrandize himself or push his policy agenda. So he isn't really a hero of the realistic school either. And something I'm trying to do here is kind of rehabilitate statesmanship as an aspiration, but more importantly, as an evaluative standard that is really the right standard by which to judge some presidents, some leaders on some occasions. I don't think our constitutional order has a large need for statesmanship. I think we need it rarely, but when the circumstances kind of dictate that we do need it, this is the right approach to judging that president's performance, because the task before him was not to push a particular policy agenda. The task before him was not to strictly comply with the letter of the law, but instead it was to do something different and to understand whether he was successful or not in his moment. We should judge him by that standard. The reason that I think it's probably not really common in our popular discourse, this idea of statesmanship, is because we only talk about it in kind of a hackneyed way. I think it was Truman who famously quipped that a statesman is just a politician who's been dead for 10 or 15 years. But the way I think about statesmanship, stretching back from classical antiquity to its more modern manifestations, I think statesmanship is something far more rare than dead politicians. So maybe one of the reasons we don't talk about it in popular discourse is because we just don't see it a lot. That's probably a good thing.
And that goes to your point, how statesmanship is dictated by circumstances and by definition isn't always something that's going to be invoked. Like statesmanship in the, let's say, mid-1990s is, I think, a little less relevant to the conversation versus, let's say, the pre-war 1930s or even the 2020s or the 1850s and 1860s in this context. So let's just focus in on something I'm really fascinated by, especially given the way you tell the story of how this article came about. In 2012, you're thinking about FDR and wartime leadership and the special relationship in the UK. That was obviously a deeply different policy and I'd say career environment for you. You're at West Point, you're going to then deploy in Afghanistan. And in the 2020s, we're sitting in a situation where we're talking about multiple theaters of conflict. We're debating the term arsenal of democracy again. The context has just changed so much. I'd love to just hear on a personal level, separate from what you actually wrote in the piece, what is it like as a person who's now thinking through these issues in a different context to go through that?
Yeah, I think to do good history, and I don't count myself among the historians. I was fortunate to do a degree at Cambridge in intellectual history, but I don't think I'm a historian. But I think I did just enough history to kind of recognize that the past is a foreign world, but in a lot of ways, and certainly the analogies can be overwrought. But I feel like I understand our moment. We're back in something that more so resembles the late 1930s, the uncertainty, the geopolitical instability than we were, during my time in the Army when I was in Afghanistan. Just a very different kind of mindset. I'll start, I guess, in thinking about how we might apply some of FDR's example to today's context with a bit of a cop-out, but I'll invoke FDR to make it palatable. He said in a speech at Gettysburg in 1938 that it seldom helps to wonder how a statesman of one generation would surmount the problems of another. And that's because each statesman has to deal with concrete difficulties that are unique to his time and not generalizable. And the other danger here, is like I said before, that among historical analogies, those from the late 1930s and World War II period are among the most used and abused analogies. But with that kind of throat clearing out of the way, I will say that I think the president today has to make the case that being the arsenal of democracy for Ukraine, for Israel, for Taiwan is an investment in U.S. national security. That's not an easy case to make today, but it certainly wasn't an easy case for FDR to make in the mid and late 1930s. There's those today, just like there were in FDR's day, that said we need to rebuild our defense industrial base, but basically just to refortify Fortress America, right? Instead, Roosevelt, against the advice of George Marshall and his other top advisors, sent abroad the first outputs of this revamped U.S. war machine. He sent planes, ships, bullets, tanks to the Soviets and the Brits at a time where we really didn't have that material to send. I think we are rightly concerned about the poor state of our defense industrial base today. But this idea that I hear, and as echoes, from FDR's time, that anything we send to allies necessarily comes at the expense of our own national security, just strikes me as really myopic and parochial. FDR sent those products of our industrial base abroad because he saw them as a kind of forward defense, a bulwark against aggression reaching our own shores. And things he did that I talk about in this article, repealing the embargo provisions of the Neutrality Act, the Destroyer for Bases deal, the Lend-Lease Act, these were all measures short of war where FDR is trying to trade American treasure for the blood of our adversaries. And I think the president's got to be able to make that kind of case today to the American people. But I do acknowledge, I think it's harder to lead from the bully pulpit today than it was in FDR's time. I'll give you just a short example. I mentioned before the USS Greer incident, right? This is where FDR's got a destroyer out in the North Atlantic, kind of in defiance of congressional guidance, and it's got British aircraft overhead, and they're leading a convoy of material to Britain, and basically fishing for U-boats. And they finally find one in the fall of 1941, and there's a clash there, wherein the USS Greer unilaterally pursues this German U-boat. FDR in 1941 had a full week to meet with his naval commanders, establish the facts, and figure out how he was going to spin that narrative, which he does in a grossly deceptive fireside chat in 1941. In 2021, June 2021, maybe it was July, but there was this eerily similar incident. But only this time, there's a Russian warship in the Black Sea with a British destroyer, U.S. aircraft overhead, and the Russian ship fires on the British destroyer. Unlike FDR, Biden didn't have a week to work out the details, to figure out what happened, and to figure out how he was going to control the narrative. Instead, in this age in which we live, on social media, you've got real-time commercial satellite imagery of the incident. You've got open source intelligence analysts trying to interpret what happened. You've got Russian propaganda there. So the information asymmetry that really privileged the president during FDR's time is just flattening today. But I think that's all the more reason that the president has to speak early, often, and unequivocally about U.S. interest in order to control the narrative.
The way you're telling the story of the Greer, I think, also reveals why FDR's experience, I think, is, especially given today's moment, a little more relevant than Lincoln's example from a constitutional statesmanship perspective, because the key thing about the way you told the story at the start with Lincoln is the war starts. Fort Sumter is fired upon. There's no disagreement about whether or not there's actually a war, whether or not there's actual stakes. Therefore, I think it's a little easy, well, not that Lincoln's job was easy, but from a straightforward political perspective, it's easier to advance the argument that these steps that push to the bounds of constitutionalism are necessary because of a threat versus, and this is, you say this specifically in the piece, the pre-war period of the mid to late 30s is one where there's actually a debate about whether or not the threat's actually real, where there actually is more of a debate on both sides in good faith and bad faith about whether or not the trade-offs are really worth it. So then I think looking at, and then that example also then of course plays into the LBJ Vietnam worst case scenario you're articulating earlier in the podcast too. So I think this really interesting distinction between pre-war and wartime when it comes to this dynamic is actually really fascinating. And I think where so much of the difficulty probably comes in. So in this last section, two big questions you could take wherever you want to go. Now that we've actually gotten into the wartime era, could you give your kind of appraisal as you articulate in the article of which decisions you think in retrospect reflect FDR getting it right? And what are ones that I think, not just the Monday morning quarterback, but I think are problematic given the framework that we established at the start of this conversation?
So let me take one where I think he got it right from the pre-war period, and then I'll do one where I think he misses the mark during the wartime period. One exemplar from the pre-war period is FDR's fight to get the embargo provisions of the Neutrality Act replaced with a cash and carry provision. So the embargo prohibited U.S. manufacturers and government from sending any kind of material to belligerents in a conflict, whether that be a beleaguered democracy or an authoritarian aggressor. And the cash and carry provision that he eventually wins enables those countries to whom we're sending aid, so long as you have the cash, you can pay up front, and you can carry those materials back to your country, we can provide that aid. And that's kind of a stepping stone to the bigger Lend-Lease Act that Congress passes. It's a really fascinating episode because when FDR first signs into law the Neutrality Act, the first one in 1935, he calls these embargo provisions wholly excellent, and he promises to clearly and unequivocally enforce them, which is super interesting because on that same bill, he writes an addendum where he expresses a lot of reservations about this bill. Instead of keeping us out of war as intended, he worries that these inflexible provisions are going to drag us into a war. By depriving the victim of aid, effectively giving aid in a zero-sum fashion to an aggressor could knock out these victims. And who knows when the U.S. is going to be next in the sights of one of these aggressors. So that's kind of one of Locke's justifications for exercising prerogative right there. You have laws in the book, but an inflexible application of them might jeopardize the public good. But he kind of keeps this reservation more or less to himself until 1939 in a State of the Union address. He talks about it publicly, but also really cryptically. He doesn't mention that he wants to repeal the neutrality laws. He just talks about how the laws might operate unevenly. Again, give aid to an aggressor while denying it to a victim. But he's really trying to conceal his intent to aid the democracies. And then he works really assiduously beneath the bully pulpit to get these embargo provisions repealed. Enlisting prominent Republicans to broadcast radio addresses in favor of repealing the embargo. But at any rate, Congress takes recess in summer of 1939 without amending those provisions. And FDR's patience is wearing really thin at this point, so much so that he writes his Attorney General, Frank Murphy, and says, "How far do you think I can go in ignoring the existing act, even though I did sign it?" Question mark, exclamation point. And Frank Murphy says, "Sir, you do not have a constitutional right to ignore the embargo provisions. It's one thing to act without congressional authority in foreign affairs, but it's quite another to act against Congress's express intent." And interestingly, Frank Murphy's position there is later adopted by his successor as Attorney General, Robert Jackson, when Jackson's on the court hearing the steel seizure case. Jackson's famous concurring opinion makes this very distinction that Murphy was drawing out for FDR right here. And Murphy, of course, was on the court too, but dies in 1949, a few years before the steel seizure case. But I like to think Murphy's actually kind of in spirit in that case, because it's just remarkable that Jackson's opinion kind of takes on the logic that Murphy is outlining here. Anyways, Congress gets back into session in August of 1939, and FDR goes immediately to the press and says, Congress has made a, quote, bet with the nation that another international eruption is not going to occur. Because if it does, Congress has tied my hands. I'm totally powerless to do anything to intervene and stabilize, a conflict zone. And not a month later, Germany invades Poland, pretty much calling Congress's bluff. And Roosevelt just encourages the public to follow public opinion or to follow these direction of events. And it does. And come November, the Neutrality Act of 1939 introduces the cash and carry provision replacing that embargo. So that's the good news, and I think that's constitutional statesmanship done right. It's a little deceptive, it's a little disingenuous, but it's not breaking rules that are not going to be put back into operation after the emergency subsides. A major failure is probably a case well known to others, and that is the case of Japanese American internment. Right, I think that fails the constitutional statesmanship standard as I outline it on all fronts. Pearl Harbor, of course, is attacked on December 7th, 1941. And in the immediate aftermath, all over the West Coast, where a lot of Japanese Americans live, employers were very skeptical of the allegiance of Japanese Americans. And a lot of employers are firing them for fear that they're going to commit sabotage against their factories, against their industry. So much so that in early January, FDR releases a proclamation denouncing this. He has some speeches basically saying, do not punish people on the account of the accident of birth. That's a Nazi technique that pits race against race. And that's not what we do. That's not what we're fighting for. We're fighting for justice and fairness. But a lot of people were demanding an answer to the quote unquote Japanese problem. And an irony kind of only the fog of war could have made true. It's J. Edgar Hoover who's opposing this relocation plan. He thinks the Army leadership is being hysterical, and he's opposed by the California Attorney General, Earl Warren, future civil liberties champion of the court, who's demanding the evacuation of these people from California. And finally, the pressure kind of, I think, just gets to FDR. And in February, he issues an executive order that forcibly relocates about 117,000 Japanese Americans and pushes them to relocation centers further inland. Clinton Rossiter said for those Japanese Americans in those relocation centers, the American Republic was nothing but a naked dictatorship. But the question from the perspective of constitutional statesmanship is whether that supplemental rule, the power to intern U.S. residents, which broke other constitutional rules like the Fourth Amendment prohibition against generalized suspicion. You need to have individualized suspicion to deprive someone of liberty. Whether breaking that rule and supplementing that rule was necessary. Was it dictated by the circumstances? That's really the question for us. And I think the historical record clearly indicates that it was not necessary. FDR's top military advisors and intelligence agencies wrote him that they didn't think that the threat of Japanese directed sabotage was severe, if it existed at all. The order is only issued 5 weeks after Pearl Harbor is attacked, and it's only put into execution, 5 months after that. So what increases in this interval between the attack on Pearl Harbor and the implementation of the order is really not the threat of Japanese sabotage, but it's popular demand for some kind of solution to this problem, all of which suggests that the order was really about appeasing certain constituencies much more than it was about preserving the public good. So I think that fails the constitutional statesmanship standard. It's kind of power without prudence. It's breaking rules without considering the necessity for doing so. And as I talked about earlier, FDR certainly doesn't throw himself before the people. He doesn't explain his reasons here, which is really remarkable because the order stays into effect until he secures his fourth term in 1944. And it's right after securing that fourth term that FDR says in a radio address that the exercise of power in a democracy is obliged to justify and defend itself within the framework of the general good. He's defining what it means to make statesmanship compatible with constitutionalism, yet he never does try to render any kind of explanation for the internment.
I think that is an excellent place to leave things. The article is Franklin D. Roosevelt, World War II, and the Reality of Constitutional Statesmanship. It appeared in the spring 2024 volume of the Texas National Security Review. Luke, thank you for joining. This was your first podcast, and I think you did an excellent job, and I think I'm looking forward to hearing more from you in the future.
Thanks. It was a lot of fun.
Thank you for listening to this episode of Horns of a Dilemma. Do not forget to read the Texas National Security Review, which you can find at TNSR.org.